Hi, everyone. This is Josh Nelson. I'm just starting out here as people get signing into our estate planning presentation today. Just wanted to welcome you to our webinar. I hope you are here and enjoying your lunch or something like that. If you're watching as a recording, that's great too. We love to do educational content. That was one of the first things that I started doing when I became a financial advisor 20 years ago, is doing a lot of educational presentations, and I still enjoy that. And I think you find it valuable as well to be able to learn, because not only is it important for you, but it's important for your family, for your friends, for your coworkers, because you may be able to pass this on to them. So as we get started here, I'm going to let people sign in and we'll get started soon. Hello, this is Josh Nelson, and I'm a certified financial planner and the CEO and founder of Keystone Financial Services. We're going to let people get signed in here. We've got another minute or so until we'll actually start sharing content, but wanted to just make sure that you are aware of a few navigational things in GoToWebinar. One of those is making sure that you understand how to access the questions and the chat features. If you're familiar with GoToWebinar, you'll know that those are in there. If not, you have a toolbar that will allow you to go in and open up a questions box and a chat box. And those are very useful, not only for you, but for me, because it helps me understand if I'm going too fast or if I need to answer a question. So definitely use those, please. If you don't hear me answer your question right away, I will get to it. I do want to be sensitive to time, of course, because a lot of people that are listening live are doing it over their lunch hour. So I want to make sure that we don't go over and we get through all of the content. But feel free to ask questions along the way. I'll also take time at the end as well. But that way, for those of you who have to get going, you can feel free to get your questions answered and then move on your way throughout the day. So as we get going here, we've got a few more people signing in here at the noon hour. Again, use the questions box, use the chat box to be able to communicate with me during the webinar. If you just have a question or a comment, or if you just have a smart aleck remark to make based on something I said, that's always fun too. We can keep this interactive. So a lot of people watch this recorded version, and in fact, we usually have a lot more clients and prospective clients listen to this after the fact. So welcome to you as well. You may be watching this well after the fact, and I appreciate you taking the time and really investing your time to be digging into this stuff, because it's very, very important. I've actually been giving presentations like this for about 20 years now on estate planning and other financial planning topics. And this one is one that's it's sensitive, right? Because we're talking about bad stuff happening. We're talking about somebody passing away or becoming incapacitated. That's why these documents end up getting used when it comes to looking at your estate planning. So I'm going to go ahead and turn myself off here for right now. But if you can hang on till the end, I'll be back, and then we'll go from there. So as far as the actual presentation itself, we're going to go through the actual slides, but I'll be making some comments along the way, certainly, because I've got a lot of experience in this area, unfortunately, because, of course, people do pass away. People do have accidents and get sick and things like that. That's when the estate stuff, the estate planning becomes very important. But here's the trick, is that oftentimes it's too late to be putting things into place. It's too late to be signing wills and to putting trusts into place, that sort of thing. After somebody is already incapacitated or has passed away, estate planning is pretty tough at that point. So this is really a proactive process. It's a process that you want to be thinking through, even though it may not be the most fun thing to think about. You want to be doing this well in advance and be thinking through not only what would happen to you in the future, but really what would happen right now. What would your plans be right now? And that's always how I suggest people approach it. I had to do that myself when I did my own estate documents, because there's a lot of sticky questions that come up, a lot of what ifs that can come up. And really, I had to tell myself that as well, as Josh, if something happened to you tomorrow, what would you want to have happen? And that does help frame the ability to answer those questions. And of course, the nice thing is that you can always change your estate documents down the road. You can change your plans if you make different decisions, but that way, if something did happen, at least you do have your current wishes and you've got those in legal form. So that being said, as we get started here, first of all, I wanted to always make sure that you know, especially when we dig into this topic, estate planning, is that I am not an attorney and I'm not giving any legal advice, and certainly don't even give legal advice one-on-one because I'm not licensed to do that. I do know an awful lot about estate planning, not only because of my educational background as a certified financial planner, but also from 20 years of seeing how this actually plays out in real life. So the interesting thing is that no matter how much planning someone does, there still are some gotchas. There's still some things that happen that people didn't anticipate, but really you're coming up with the best plan that you can, and certainly working with professionals, myself, when you're working with a certified financial planner, they're also going to be engaging other experts into the mix to build your plan. One of those would be an estate attorney, certainly would be somebody to consult with to do your estate documents, to give you legal advice. Financial advisor does not do that. They would bring in somebody else to do that, as well as tax advice. Typically, a CPA would be the person that we would bring into the mix to answer tax questions or consult with from a tax basis. So that being said, let's get going. So again, I'm Josh Nelson. I'm here in the lovely city of Loveland, Colorado. I know there's a lot of people that dial in from around the country, so thank you for tuning in today. And again, this could be a recorded version as well that you're listening to, but again, thanks for taking the time. Certified financial planner means that we are trained to handle kind of head coach responsibilities. When I think about what a CFP does, it's kind of like coaching a football team. We'll use the Broncos since they're in our backyard, but clearly the head coach can't do everything. They're not an expert in everything, and that's why they hire other people. They hire other coaches, the quarterback's coach and the defensive coordinator, others that would be bringing them into the mix, but it really is the coach's responsibility, and that's why he can get canned, of course, if things don't go well, but it's his responsibility to make sure that they know where everybody is, that they know what the strategy is, and ultimately they have an outcome. And of course, with the CFP, their goal is to achieve your outcome, right? We work for you as a fiduciary. We're actually legally responsible for making sure that we're giving you advice that's in your best interest first, and that we're disclosing any conflicts of interest. Certainly it helps to be fee only. If an advisor is charging you a fee as opposed to commissions or something like that, it definitely helps because it puts your interests a lot more aligned than if they worked for a big company and the company was telling them to recommend products or something like that. But part of the CFP is certainly estate planning. I think it's one of the more interesting areas and probably one of the more misunderstood areas as well. So as we get started here, let's talk about the agenda. First of all, who needs an estate plan? We're going to talk about the goals of estate planning and really what does all of that mean. We'll talk about wills and trusts, some of the mechanics then as far as what types of documents, what types of things would people be putting into place to be able to execute their wishes. Some other considerations, we'll talk about healthcare, certainly some of the living issues. If somebody's incapacitated or has end-of-life directives, we'll talk about what that means. And then ultimately, we'll talk about transferring wealth. So first of all, who needs an estate plan? Oftentimes, people get intimidated by this and they think, well, that's not for me. Estate planning, that's just for rich people. That's just for people who have gazillions of dollars and that can't possibly apply to me. Or they start thinking, well, it's just a tax issue. It's an estate tax issue. And I heard that the estate tax exemption is over $5 million now and my estate isn't that big, so not for me. The reality is estate planning is for everybody because as long as you've got things, stuff, property, you have an estate. And so the estate plan simply is to have a plan around that estate as far as what's supposed to happen to our stuff and how we would want to have our affairs dealt with if we were to pass away or become incapacitated. So this is for everybody. I can tell you from experience that sometimes the smallest estates can be the ones that cause the most problems. So this isn't an estate size thing necessarily. Somebody could have a relatively small amount of property and it ends up causing a lot of headaches. And I can tell you, oftentimes the goal of estate planning for people is to make things easy on people. So one of the things that people certainly would be looking at with regard to having an estate plan is to naming who should receive your stuff, who should receive your property in the event that you pass away. or become incapacitated as far as how is it to be managed after your incapacitation. Also, transferring property to your heirs, any organizations you've named, so charities. If you want some money to go to charities, you're probably not going to give it to companies, right? So organizations would be nonprofits. So how that's going to be dealt with, that could either be done while you're living or after you've passed away. So estate planning is not necessarily just a death thing. It could be that you're doing some gifting along the way and making some gifts of property or cash along the way. Certainly minimize or eliminate estate taxes. This isn't an issue for most people right now. And I say right now just because the estate tax exemption is quite high. It's over $5 million each from a federal standpoint, meaning that for most people, their estates are smaller than that. And certainly if they're married, that's over $11 million that they would have that they could potentially pass on tax-free without an estate tax. In Colorado, at least, we don't have an inheritance tax, so that's not an issue. But some states do have an inheritance tax, and that could be an issue depending on where you live or where your estate would be settled. But that typically is a goal, is to try to minimize or eliminate estate taxes and expenses regarding your estate. State taxes, of course, that goes to the government, and that's usually an objective of people, is that they're not leaving money to the government. They'd rather have it go to somebody, a person, or to an organization, a charitable organization that they would be making the choice on. Naming an executor and or trustee. So one thing that there definitely is a differentiation here, and we'll talk about that as far as what that means. Avoiding probate. Sometimes probate's not the worst thing in the world, but a lot of people do want to avoid probate because there can be some different expenses. It can be a lengthier process. Sometimes it's a privacy issue where people say, you know what, that probate process, that's a public process, and I don't want anybody to see my stuff. I don't want them to see how much I was worth or any of my business affairs. And so sometimes people do have that objective of avoiding probate, sometimes not. And documenting the type of life-prolonging medical care. We talked about that a little bit before, that you do or do not wish to receive. Typically, that would be called a living will, and we'll talk about that as far as making sure that those wishes are documented. And then ultimately, again, expressing your wishes and preferences. There's a lot of stuff that can go into estate documents, and sometimes it's not even just the money. Sometimes it's not even just the property. It could even be some preferences and wishes that people are making sure are really clear in those documents that they prepare. So one big question is, do I need a will or a trust? In fact, I'd say that's, for an estate attorney or an estate planner, that's probably the biggest question that they're getting, is do I need a will or trust, and what does all this mean? And the reality is, it depends. That's my favorite answer, of course, is it depends, because it really does depend on your particular situation. A lot of it depends on what type of property you own, right? So it could be a situation where you've got property in multiple states, real estate specifically, and that could change things, even for a situation where maybe Colorado or another state that has a more simplified probate process and a less costly probate process. If you own property in multiple states, all of a sudden you're possibly dealing with multiple probates, and that can mean that maybe doing some proactive work and then setting up a trust in advance could actually help with that. Usually, people will actually still have a will even if they have a trust, and we'll talk about that. But usually the will is there, if nothing else, to be able to act as a catch-all for property, and also to be naming, in my case, I've got 4 kids, so I'd be naming the guardian in there, the person who's supposed to take care of my kids if something were to happen to me. Now, on the left-hand side, you can see, and this is for clients working with financial advisors, which helps a little bit, but you can see in the stats that only 55% have estate plans in place, and I'm embarrassed for my profession that number is so low. I can tell you that the overall national average is that about 70 to 80%, depending on what statistics you look at, about 70 to 80% of people have done no estate planning whatsoever. So I guess it helps. The stat says that it helps to have a financial advisor, but unfortunately, a lot of the financial advisors out there are not doing proactive, comprehensive financial planning. A lot of times what's happening, I find, when people come to me and they say, well, I work with this other advisor, what we find is that oftentimes the person is more just a product salesperson, or they're just looking at one aspect of the financial plan like the investments or like the insurance, when in reality, estate planning is a really, really important part of the overall plan and has to be looked at. So again, makes me a bit embarrassed for my profession, but that's something that we are talking about with clients. 36% had trust services in place. In other words, they have a trust department or they have a trust document that would administrate their stuff. And then 27% acknowledge an estate plan is needed. So I think that kind of lends itself to my original comment that a lot of people don't think this is for them. A lot of people think that they don't have enough money or enough stuff or enough complexity to deal with. And I can tell you that that's just not true. My daughter, who is 11, just bought Amazon stock, so now she has stuff to deal with, right? She owns property even at such a young age, so hopefully those habits continue and my kids continue to buy investments and build up stuff over time. But even with a small amount of money, there now is something to deal with there. So let's talk about a will. What is a will? So a last will and testament, typically that's the wording that you would see on the document, is last will and testament. And the primary things there, number one, making sure that your stuff will be distributed as you wish. Now, I use stuff kind of loosely because we've got things, we've got stuff, we've got property, basically. We've got things that could be accounts, it could be real estate, it could even just be stuff. It could be vehicles, it could be antiques, paintings, all types of stuff that you've accumulated that you own, in other words. So making sure that that's distributed as you wish. And this isn't even a married versus non-married issue. If you're married, it's just as important to make sure that all your wishes are carried out, and if nothing else, make it very easy on your surviving spouse or on your kids or whoever's dealing with your stuff after you pass away. So it also allows you to appoint and outline the powers of an executor, or you might have heard the term executrix. Oftentimes it used to be that there was an executor if you were male, executrix if you were female. Now I think it's just executor universally, or personal representative, depending on the state, will be the term that's used. But basically it allows you to name who that person is, and also to be naming if there's supposed to be a backup. And that would always be a good idea, I think, to name a backup, because we don't know, right? When we're executing these documents, not a bad idea to name more than one person or some succession if something happened to your executor, or maybe for whatever reason they put in place documents and 15 years from right now you pass away. Well, who knows? Who knows what the situation is if they've passed away, if they're incapacitated. Maybe they're in a situation in their life where they just can't take it on. Maybe it's not something that they can take on. Guardian for minor children, I mentioned that. Specify funeral wishes. And so a lot of times this does come up in conversation, especially if you've had a loved one that's passed away, say a parent. You know how stressful that can be, not only, especially if it's a sudden death, not only trying to deal with just the emotional impact of it happening, but also now trying to make decisions, having to make a bunch of decisions at a very, very short amount of time as far as what the burial wishes are, cremation or not, even down to some people will even go in and say, you know what, I'm going to actually put into place the songs that I want played and where I want to be buried and what type of arrangements I want for a reception afterwards. There are prepaid funeral services, burial services out there that I know some people have signed up for that can help with some of that. But it does give you the ability to make your wishes known. Certainly expedite the legal process. If you don't have a will, you are what's called intestate, which means that you don't have a will, and so you're basically subject to the state's laws. There's a set of state laws that basically deal with your stuff and kids and things like that. You know, there's a legal process that will still carry it out, but it may not be according to your wishes. That's really the idea here. I heard one estate attorney describe a will as a letter to the judge, a letter to the probate court judge saying, here's what I wanted to have happen. And again, reduce stress and heartache for loved ones during a very stressful time anyway, certainly for a spouse, for children, anybody that you were close to, of course, which would probably be the same people that would be making decisions and impacted by you passing away, not only from a financial standpoint, but really you think about it from a business standpoint, just kind of dealing with the logistics of people's property, of the stuff in their house. Again, funeral arrangements, trying to comfort other loved ones. I know, we've all been around long enough. We probably have had somebody pass away in our life that was close to us. So you know what I'm talking about. And certainly it's all something that is just part of life, but certainly as part of this process, it does make things easier on the people that you love and on what they're going to be dealing with after you pass away. So the role of the executor, again, I use some other terms, so we'll just use executor for the sake of today, but it's personal representative, executor, executrix. So what it does is it provides them the legal authority, responsibility to manage your stuff and to handle kind of the day-to-day financial matters after you passed away. So the executor, they put that hat on after you've passed away. If I pass away right now, my executor, all of a sudden they can put that hat on. So this only applies after somebody's passed away. But it's really important to think about that person and who that would be and who your backups would be, because they do have an awful lot of responsibility. They have a lot of power too, right? They've got some legal authority now, and so carrying out your wishes, that is their job, is to carry out your wishes. But if you name, say, a child or maybe a family member who isn't good with money, or they're just not somebody who's good with following through, that is probably a recipe for disaster. That's not a good idea to name somebody that really isn't capable or willing to do that. So that's one good reason as well to add a backup, to add somebody who would be a backup. Or some clients I've seen with their attorney, they maybe will name co-executors where maybe there's two kids, and so they name two kids as the responsible parties. So that adds some accountability and transparency into the process. So it's really important to think about who this person would be and, again, who would be your backups, but that would be indicated in the will. So let's talk about a trust. What does a trust mean? So basically, it's an estate planning tool. It's a document like a will, but what it is it's a trust that would actually add a lot of structure in place, and it also can be a document that can act while you're living versus a will. A last will and testament is only after we've passed away. A trust can actually be handled while you're living, possibly when you're incapacitated, maybe not. A trust can kind of say whatever you want it to say, subject to law, but a trust can be pretty flexible and be much more specific as far as how things are to be handled. So the different types of trust. First of all, there's a revocable trust. You may have heard this called a family trust or a living trust. So revocable, as it sounds like, it's revocable, right? As long as you're living, it's something that you could get rid of, you can terminate it, you can change how it's managed. So it's called a living trust, or a family trust or revocable trust would be typical wording. If you're looking at your documents, for example, or your parents' documents or something else, that's probably what you're looking at. So it can be modified, terminated. You control the trust, and any earnings basically would flow through, as long as you're the trustee. Basically, that would flow through to your personal income tax return. So there aren't any special tax considerations. Oftentimes, I think this is just a misunderstanding that a lot of people have, but they say, well, I'm going to do a trust because I want to save on taxes. And, while they're living, in other words, it's a living trust. They say, well, somebody said I can save a bunch of taxes. You won't save any taxes. It's not going to save any income taxes while you're living, because it does flow through to your personal tax return. So keep that in mind. You can manage the financial assets, as long as you're the trustee. You can manage the financial assets held in the trust as long as you're living. You can manage it, or if you've got co-trustees, maybe it's you and a spouse or somebody else, you have the ability to manage those assets held in the trust. And those assets could be a variety of things. It could be stock. It could be a bank account. It could be a vehicle. It could be real estate. There's all kinds of things that you could hold inside a trust or would be titled in the trust. But it would result in, if you did one of these, basically it results in you probably changing the titling of the property, or at least naming the trust as beneficiary of that property. And I say that because I've seen this happen a lot of times over the years, where somebody will come in, probably a new client, they come in and they bring all their stuff in, and we start going through everything and we figure out, oh, you've got the family trust. that you put together 12 years ago, and somebody helped you write it, and it's really pretty in a big binder and fancy lettering and all that. But then when we dig into it, I start to ask them questions and ask them, well, what's in the trust? What actually has been titled in the trust? And what we'll find out a lot of times is that the trust was never funded, that people never changed the way those assets were titled. And so, and oftentimes, I see this just really expensive paper, basically, where somebody may have paid thousands of dollars. And, it took a lot of time from an attorney who probably was really well-meaning. And it was just the person's responsibility, though. It was the client's responsibility to go in then and change the title of their property or change how beneficiaries were listed. And they didn't follow through. They didn't follow through. And really good estate attorneys out there, they will certainly handhold people and help them figure out exactly what that means, what are the actions they need to take. But certainly a situation like this, if you're going to spend the money and the time, certainly to make all these decisions, you definitely want to execute the trust, actually make sure that titles are changed, beneficiaries are changed. So just doing a will or doing a trust doesn't necessarily magically take care of all your stuff. It is going to be some work to make sure that everything actually flows the way you would want it to. And then again, it can be used to transfer assets at death, similar to a will. Irrevocable trust, as it sounds like, can't be modified. So basically, once you put it into place, you're transferring property into a trust, and it typically is irrevocable. Once it goes in, it's really outside of your control for the most part. It can't be modified or terminated unless you go back to court, and of course that may or may not work, and it could be really expensive, and you'll pay attorneys and all kinds of stuff, right? So clearly, an irrevocable trust, you want to be really, really sure you know what you're doing. It's not to say it's not a bad tool, but we definitely want to make sure that it's well thought out. So this one is a little bit different, and it's a separate legal entity. It's its own taxpayer. It gets its own tax ID number. So this does not flow through to your personal taxes. And sometimes that's people's motivation in doing an irrevocable trust, because they're trying to reduce either income taxes now and possibly estate taxes in the future. If they've got a really large estate, they might want to actually put money into the trust now. Sometimes it can be used with life insurance policies. If you've heard of an irrevocable life insurance trust, that's my financial planning gobbledygook, right? But if you've heard of that term, it usually means that it's an irrevocable trust that was set up with life insurance. So it could be a way to benefit either a charity or individuals in the future. We don't see this as much now, for sure, and that's because the estate tax exemption amount from a federal standpoint is, again, north of $5 million each right now, and the vast majority of Americans don't have more than $5 million. When they do, again, we have to look at, are they married or not, and if they're married, then they kind of get double that amount. And certainly for really large estates, then some of these things can be put into place that could help out. Or if you're in a situation where you just know that you want to give property at your death to a charity, and you can put it into an irrevocable trust that would make sure that happens and it gets it out of your name. Another time that this could be useful, and again, I'm not an attorney, so don't throw stuff at me, but sometimes people will ask, well, I want to protect myself from a long-term care situation, and I've heard that if I put all my money in a trust and it's protected and the government can't come after it. Well, it depends. Certainly talk to an attorney about that one, but it depends. If it's a revocable trust, I can tell you, though, that will not help at all. I can say that with a large degree of certainty, because revocable trusts are not, they don't really count, as a completed transfer, a completed gift to somebody else. So currently the rule is that if you apply for Medicare, then what will end up happening is that, or Medicaid, excuse me. Medicare is a different thing. That's health insurance. But with Medicaid, what will happen is that they have Medicaid investigators, believe it or not, that will actually go back and see, did you give away all your stuff? And typically it's a 5-year look back is what I've seen. So we want to be careful with this and be really cognizant of the fact that just putting money in a trust doesn't necessarily protect you. There could be look-back periods, and it could be a situation where you put it into a revocable trust, which basically is still yours. It's still in your name, so that really doesn't help you at all. So it's one of those things that it's a whole other area of of law, certainly, and elder law typically is what we're looking at, because usually it's later on in life, or it's the kids saying, well, maybe we should put mom or dad's money into a trust. Definitely want to be careful with that, because it may not accomplish what you want it to accomplish, first of all. And it could also be a situation where you lose access to the money. In an irrevocable trust, you pretty much lose access to the money. And once people find that out, they find that it's not very attractive. They find that that's not what they want to do. Okay, so let's move on. And actually, I saw in the questions box here. Oh, Mark, yeah, you contributed that 11.2 million, exactly. So $11.2 million is the amount for per person. Yeah, and actually, yeah, I misspoke. It actually did get raised after this last tax bill, the Tax Relief Act that we had here a couple of years ago. So now we need really, really, really large estates. And but it's one of those things, though. Politically, the pendulum swings, right? And I could see where, especially as we hit the late 2020s, early 2030s, when they say Medicare and Social Security and all these programs are going to go broke, it could be that politicians like the idea of going after estates again, and much smaller estates. The trick is, and I'll get off this in just a second, but one thing to think about with the estate tax is that oftentimes who it really impacts is people with illiquid property. In other words, it could be that a family owns a ranch, or they own a business, or a bunch of property, and or a farm, for example. Oftentimes these things can be worth a lot of money, especially right now in a lot of areas. Land is worth a ton of money. And so oftentimes the vast majority of the family's wealth is illiquid, but if the estate is too large, then what happens is that the estate tax hits, and you probably have heard of situations like that where people have had to liquidate the family farm or the ranch or something like that they held for generations. Really sad situations, of course. So that's one of the reasons why the estate tax exemption has got raised to a much larger amount now, the $11.2 million per person. All right, so roles in the trust. One thing to keep in mind is that there are different roles, there's different hats that get worn by different parties in the trust, and they could all be you, by the way. So the grantor or the settlor, that basically is the person, you and or your spouse are the people putting the money into the trust, putting the property into the trust. Then there's the trustee, and the trustee could also be you, especially if it's a living trust. That would be typical that I see, is that usually people are named as their own trustee as long as they're living. And so that could be a person, or it could be an institution. And I say that because if you've ever heard of a trust department, say of a bank or a trust company, that's what that is, basically, is that they're able to act in the capacity of a trustee in absence of having a human trustee, of just a person that's named. So you have the ability of naming who that trustee is. They can be appointed either in current time, of course, they could be named now as trustee, or you could name that trustee as somebody or an organization that would take over if you were incapacitated or if you were to pass away. So oftentimes what we'll see in documents is that we'll see people name themselves as trustees, but then they'll name a successor trustee, and a successor trustee means that that's who takes over if the trustee has been incapacitated, they're unable to serve, they passed away, then the successor trustee takes over. So it's a little bit like what we were talking about with the will, that it's not a bad idea to name backups because you don't know exactly what's going to happen. In some cases, what will happen, I'll see, is that it'll be, say, husband, wife as co-trustees on the trust, and then maybe it's the kids that are named as successor trustees, or maybe one of the kids that maybe they're financially savvy and good with business. So the one thing to think about is that if you look at a scenario, and it happens, right, is that somebody does these documents, they execute these documents, and then they don't look at them for 20 years. There's a lot that can change in 20 years, and the people that you may have named, and so this is your homework, is that if you have estate documents, it's probably time to look at them. If you haven't looked at them within the last few years, it's probably time to go back in and look at what does it actually say? What do your documents say? And more often than not, when we look through documents with people, because oftentimes they'll bring them in and they'll say, hey, let's look at them, and they haven't looked at them for years and years. We'll actually go through and we'll find out that, wow, I named that person, and I don't even, maybe it was a family friend that you're not family friends with anymore, right? Or it could be a sibling that's passed away, something like that, right? So it could be that was the only person named, and that means that you don't have anybody, right? And that puts us back into a bit of a mess because we don't have a clear person that would be responsible. That's one benefit that I'll plug, is that having a corporate trustee, and we actually do have a trust department available through Carson Trust that you could name as successor trustee, but it's not a bad idea to name a corporate trustee like that, or trust department, basically as a backup, even if you've got humans that you think would be good to serve in those roles. It's good to have them as a backup, because a trust department, unless for some reason the organization's not there, they go broke, something like that. If it's a major trust company, not likely to happen. But that way there is kind of a fallback, even if you had some humans in mind. And then in some circumstances, what I hear from folks is that they say, and this kind of applies to all this, right? The executors, the trustees, sometimes people say, I don't know who I would name. Maybe it's a situation where if something happens to husband and wife, they may not have a clear person that they would want to name. And the thing is, too, is it's not even just trusting the person, but it's a lot of responsibility and a lot of time probably that person is going to put into making sure that all your stuff is taken care of. So it may not even just be a situation of their ability to serve, but maybe their willingness to serve. It may not be a place in life where they can dedicate that much time to it. So oftentimes heard they say, pick your least favorite kid and name them as trustee, right, or executor, because it's a lot of work. So just keep that in mind. Keep in mind that it's never a bad idea to talk with your attorney, add a successor, have a backup, in other words. So then there's the beneficiary, and that's, of course, the people or the charities that benefit from the trust. That's who gets the money basically when you pass away, or if it's a current trust. There are trusts that actually can kick out current benefits to beneficiaries even if you are living. So trusts are pretty flexible in that it's just a matter of the ability of the you and the attorney, basically, and your financial planner, to be creative and figure out what do we really want to have happen and what fits for our family. All right. And I saw another question come in. Mark asked, in your area, how much asset value do people need before a bank trust department or financial company will agree to be a trustee? It depends on the company. Sorry, I just got a new Apple Watch, which is really cool. I got it for Father's Day, actually. Really good Father's Day present. Probably the best I've ever gotten. But I don't know how to silence it at this point, so pardon the ring. But as far as dollar amounts, it really depends. It depends on what company. I think with Carson Trust, it's $800,000, so it's not really high. Some companies will want much higher dollar amounts, so it just depends. There's big companies like Northern Trust. I think they are the biggest in the country that have they will either have much higher minimums, or they will charge a lot of money, if you have a small trust. So, that's a good point, because sometimes you kind of have to look at how cost effective. In other words, somebody might think, well, I'll just name a corporate trustee right off the bat. I won't even name any of my kids. But then we start to dig in and look at cost, and maybe it's a simple enough situation that maybe the kids are going to easily be able to handle it with their attorney, right? It could be something where somebody is named, but they're actually getting assistance from their financial planner, from their attorney, from the CPA. And from a practical standpoint, I can tell you that that's what happens when somebody passes away or becomes incapacitated. We are kind of their succession plan. That's why people come to us in a lot of cases, because they say, you know what, I've been kind of handling my stuff, and usually it's one spouse or the other has been kind of the lead on the financial management, the business management of the family. And then they start to think, well, if something happens to me, is my spouse going to be able to handle it, my kids and so forth? So it definitely does help to have that. And from a practical standpoint, something happens, we pull a team together. We pull together the financial experts that we need, attorneys, and certainly the family, and then talking through how everything works. as far as asset transfers and management of accounts and so forth. So so dollar amount does matter. If it's too small of an estate, it starts to get pretty expensive, or with some situations, trust departments won't even act. They won't even take accounts under a certain size. So kind of keep that in mind as you're thinking about that. And certainly contact me individually too if you want to talk through that. So some additional considerations, and of course there's a lot. I could talk for hours with all the estate planning horror stories and things that I've seen happen and family situations, and you guys could too, right? I could open up the mics and we could all tell our war stories, right, of things that happened in our family or our neighbors or friends, things like that. But some additional considerations to definitely think about. We talked about incapacitation before, and typically in a estate document package, the average person that walks into my office and gives me the binder of stuff, typically it's going to be a last will and testament, like we talked about, possibly a trust, or could be even more than one trust. You can have as many trusts as you want. It'll just make it more complex and more costly probably, but sometimes there's reasons for that, right? And I'll use myself as an example. I actually have as my beneficiary, one of my beneficiaries is my children's trust, because all four of them are minors right now, and they're too young to be able to handle the finances. And I wanted to be spelled out that not only do they get the money, right, but I've got it spelled out when they get the money and how it's to be used, simply because even if the kids are a little bit older, how would you like to be an 18-year-old or 21-year-old and have a windfall, have a bunch of money drop in your lap? I don't know about you, but I can't think of too many 18 or 21-year-olds that would handle that very well, even if they don't do something destructive with it. And that happens too, certainly, where all of a sudden, drug, substance abuse, craziness can happen. But also, an 18 or 21-year-old probably is not going to make good financial decisions with that money. They could be taken advantage of, certainly. There's a lot of fraudsters out there that would love to, give them investment advice, right, that probably would not be in their best interest. And, of course, when somebody receives wealth, oftentimes what happens is friends that you haven't talked to for a long time come out of the woodwork. We always see this with lottery winners and NFL players, things like that. When there's sudden wealth situations, it usually does not end well. Usually that money goes away pretty quickly. And again, it's a situation where somebody's worked their entire life, or even it could be multi-generational wealth. It can go away pretty quickly. But going back to other documents, advance directives. So advance directives basically would be something like a medical power of attorney that would give somebody else the ability to make medical decisions on your behalf if you're incapacitated. Or it could be a financial power of attorney where somebody has the ability to do business and pay your bills and so forth. So, and naming backups there is important too, right? So it's important to think about who you're naming as your power of attorney, who's the backup, in what situations would you want them to be able to act. Would you want it to be effective immediately, or is it only if something happened to you? So there's all kinds of considerations there. Certainly that's where the attorney is invaluable, because they can actually draft that language and make sure that things are carried out on your behalf. And then we talked about the living will. Living will typically is going to be a document that would be your end of life directive. And so my end of life directive in Colorado, it's pretty cut and dry. The language gives you, it's three choices. Do you want to, in other words, if you're on life support, if the only thing that's keeping you going is artificial nourishment, do you want to be kept going indefinitely? Do you want them to pull the plug? Do you want to be kept alive for a certain number of days? I think that's what it says on mine. So, certainly talk about that with your attorney, but keep in mind that anything that you are putting into place is not just for your peace of mind, but it's also thinking about your family and thinking about your loved ones, the people that realistically are going to be the ones dealing with all of this. And if even just that one decision, right? Even just that one decision as far as your end of life wishes, if that decision was already made, then that takes an awful lot of stress off of the family, especially where there's maybe multiple children and family members. And of course, we've heard headlines of this, right, where people are fighting over family members, somebody who's incapacitated. terrible, terrible situations that could be avoided by that. Now, another thing to think about here too is where is this stuff kept? And that's really, really important because there's no central repository out there that somebody can look up and see, well, did somebody have estate documents? There's also no central repository out there on where your life insurance is or what companies might have your money, even banks. So when somebody is not organized, and this is a lot of the work we do, by the way, for clients as they're coming on board, is we spend a lot of time organizing things, making sure that everything is in one place. We know where all your stuff is, your policies, your state documents, not only for you, but also because we are going to be the ones dealing with your spouse, your kids, your family, if something happens to you. So really, really important that they know the location of this stuff, because not always so obvious, especially in older generations. What I've found is that people, especially if they lived through the Great Depression, that was pretty formative. And a lot of people end up squirreling money away either in lots of different banks or even in cash. I have clients that they just retired from this, but they had an estate sale business just as kind of a fun retirement business. But you wouldn't believe the stuff that they found, in people's furniture and mattresses and things like that. The type of stuff, cash, in other words, cash and gold coins and all kinds of craziness. But it's really important if somebody doesn't know where that is, there's a pretty high likelihood that that's not going to end up where you want it to be. And certainly situations like this, like end of life directives, medical directives, people who are supposed to pay your bills, if these documents are locked up off in some safe deposit box at a bank that nobody knows about, that is just really expensive paper that's not going to do anybody any good. So it is important that you are talking to your family. Make sure that they understand where your stuff is. Maybe even have the discussion about what you want. Maybe even tell them, this is what my documents say as far as how my affairs are supposed to be handled. I can tell you that especially in situations I've seen where there are unpopular decisions, maybe where a certain portion of the estate that was supposed to be going to a certain kid is handled a little bit differently, or maybe it's not the same amount, or there may be some misunderstanding because mom and dad gave a loan to sister and not to the other kids, and now all of a sudden that wasn't made clear, and so now there's fighting. That's terrible when that happens. It really is awful, and even in the best planned estates, there's always some level of tension, it seems like, just from what I see. You can really alleviate that by communicating in advance. If your kids don't like your decisions, at least they can be mad at you instead of mad at each other. We hope, anyway, and certainly so they know where your stuff is. Along with this, and it's not in my slide here, but another thing to think about is, do your loved ones have your social media passwords, your computer passwords, things like that? We've done a series before on identity theft, and the good news is that there are so many ways now to protect our information. But one thing to think about is if it's too protected and nobody that you care about knows how to get access to it, all that information could be gone. They could be irretrievable. And now all of a sudden, all your digitally stored photos and important documents, things like that, could go away very quickly. And of course, that'd be really sad if that happened, but it does happen. And we used to worry about, well, we need to have fireproof boxes and things like that in our homes in case there's a fire and it needs to be rated to a certain temperature. Of course, that's still important, but now it's, well, we've got a social media account, maybe somebody's Facebook account that they've been running for a decade, and all their memories and photos and things like that, and then nobody has any access to it, and they want to go fight with Facebook now, to try to get access. What a mess. So really, really important that the communication is really clear, because in a lot of cases, this stuff is irreversible. There's no way to actually get it back once it's done, or decisions that have been made once they're done, even if somebody finds something later. Now, the other thing to think about is that your existing documents, you might have existing documents that are in place, and You might wonder, well, do I just start from scratch? How do I even know that these are good? I did them 20 years ago when my kids were young, and now they're adults. So it's probably a good idea to review those documents. At the very least, read it yourself just to make sure that it still makes sense. It still does what you want it to do. But more than likely, with that many years that have passed, it's probably a good idea to sit down and have an attorney review it. It's a good idea to have them review it just to make sure that the law hasn't changed such that your wishes wouldn't be carried out the way that you originally wanted them to be. Or it could be that your situation has changed enough that you've got a much higher net worth now and much more complexity in your estate situation where you may have done a very simple will originally, which good for you. You were in the percentage of people that actually took action and were proactive about your planning, right? But if you put together a really simple will earlier on, it might not be the document that does the job anymore. Maybe you do need a trust now, or maybe there's been some life circumstance where we see this happen, right? Where maybe there's a kid that originally you were okay with them and thought that they were on a good trajectory, and now they're not. For whatever reason, they're making some really bad decisions, and you think about it and say that would not be good for that kid to get a bunch of money all at once without some safeguards. Or it could be a situation where it's a special needs situation where you've got a child that really would never be able to handle their finances. And certainly if there weren't some protections, you could actually end up impacting some disability benefits and things that they were receiving. Yeah, and Mark commented here, he said, good idea to have several people you trust to have the authority to get into your safe deposit box when you can. And oftentimes people do have a safe deposit box. And so you actually can name, most banks will actually let you name people at the bank. You can sign a document that says this person, and this person are all given access. And so they would just need to show their ID, be able to identify themselves to get in. And that's one reason I've heard some attorneys say that really a safe deposit box isn't always the best location for estate documents, especially for things like an end-of-life directive or medical power of attorney where decisions might need to be made very quickly. There may not be time to get to a bank, or it could be that the bank has closed over a 3-day weekend or something like that. May not be the best place to keep some of those things, and it may be a better situation to have it in some type of a filing system at home. It's up to you, obviously, whether you make it be a safe or fireproof or whatever it is. So, like I said, there's a lot of additional considerations, right, that we could talk about, but really this isn't meant to give you a comprehensive estate plan today. This is really to hopefully trigger some things that you may not have thought of. And maybe you did think of it, but it's been so long that you're not quite sure at this point what your documents say and if they're still appropriate for what your family needs at this point. So transferring wealth, a couple of things before we go to Q&A. So transferring wealth, it's a big deal. We've got trillions and trillions of dollars that are going to be passed over the next few decades. And of course, baby boomers to Gen X to millennials, 70% of the family money disappears by the end of the second generation. It seems crazy, but that stat before was sudden wealth. As far as NFL players and inheritances, it kind of all applies the same in that a sudden chunk of money that makes it to somebody, especially if they haven't been used to dealing with a bunch of money in the past, that usually does not end well. It usually does not end well, and that money goes away very, very quickly. And then 90% gone by the end of the third generation. And this applies not even just with money either, investments. This also applies to family businesses. Yeah, there's lots of stats out there about that. Most family businesses don't make it past the second generation, and there's a variety of reasons for that. But wealth in general usually does not make it that long. So the more planning that you can be doing, and some of that certainly can be done by example, right, and helping your kids start to learn about money. If they're not financially responsible, regardless of what their age is, see what tools are out there to be able to help them out if they're willing, right? Maybe it's buying them a book. Maybe it's that you encourage them to talk to me or somebody on my team. We'll certainly give them a free consultation to be able to look at their stuff and to be able to help them make some good choices and start developing some good habits more than anything. Because more than anything over the last 20 years, what I found out is that where people end up in the end financially has very little to do with getting lucky, has very little to do with some sudden windfall or working for the right company. And once in a while, right? Once in a while, there's some luck that comes into play, and that helps. But usually the trajectory of people's wealth has a lot to do with their habits. It's a lot less to do with what job they had or what types of benefits they had at their company. That stuff all helps, but habits really build up to the end result. So with that being said, I will throw it out to questions. And as I'm waiting for some questions to come into the queue, I'll throw out a couple of things. First of all, if you've got questions that you have individually that you don't necessarily want to share with everybody else, and that's perfectly understandable. I probably wouldn't either, if it's a detailed family situation or something like that. Shoot me a phone call, certainly, or an email. I'll put my contact info on here, josh@keystonefinancial.com. And certainly for any resources or learning more about our firm, keystonefinancial.com is our website. But reach out. We're pretty available. I try to make myself pretty available to talk with folks. So certainly reach out with any questions that you might have. Also, we have some resources available through Carson Group. There's actually a free consultation available. So this does not replace your attorney or CPA, certainly, but free consultation available from an attorney on staff where they can actually look at the document with you, look at your existing document with you, and at least give you their take as far as this is what this says. They'll give you a summary, in other words, of this is what this says. So you can at least identify that, yep, that's pretty much what I thought and that's what I want. Or it could be something that raises the flag and says, you know what, I need to do some work here and need to make some changes to what I've already got. So a couple of things as well is that financial planning consultations with us, certainly a first consultation available at no charge. After that, we'll talk, about you becoming a client, and that could be any area of financial planning that we talk about. We are a fiduciary. We are fee only on the investment side, so we don't charge you any commissions on your investments. You pay us directly through your accounts. And then the last thing is that from a safety perspective, we do not hold on to any of our clients' assets when we're doing the investments. Those are all held with a third-party custodian, Fidelity or TD Ameritrade. All right, let's go into the question queue here and certainly keep asking them along the way. So let's see. Yeah, one comment here, it wasn't a question, but one comment is that one person said, as far as distributing assets to children, would rather not give them too much at first and maybe deferred inheritance plan. So maybe it's gradual over the years as they get older. And I can tell you that's how mine is. I'll just throw it out there. That's how my estate documents are set up, is that my children, although they receive an inheritance, certainly they don't receive it all at once. And especially in the younger years, it's only for specific reasons that they really have access to much of the trust anyway, but it's divvied out to them over chunks of years until they get older. Now, is that a guarantee that they'll handle it well? No, absolutely not. There could be a kid that's a complete bozo. We'll see which one it is, right? Hopefully none of them are bozos, but they could be a complete bozo and still blow it all, even if it is divvied out over time. But I think it does help. I think that comment's very valid, that it does help to not drop a big chunk of money on somebody at one time when they weren't used to having it, they weren't used to managing it, they weren't, frankly, the one who accumulated it, they weren't the one who sacrificed to build it, whether it's a business or a 401k. That all culminated from a sacrifice that somebody made. So they sacrificed an awful lot of time, and they probably they forewent a lot of experiences and stuff they could have bought, vacations they could have taken, right, with 401k. So think about that. Think about that sudden wealth for most people does not end well. And at the very least, you don't want to set somebody up for failure. You want to set somebody up in a situation where they're going to have some help. And certainly we help a lot of people's kids after they pass away. Obviously, they have to be willing to listen, right? But through some of your estate planning, you actually can set aside some of those things. You can actually have some of those time periods. You can also certainly mandate it in there that, there's going to be a trustee, and You can even name us as investment advisors, so we would continue to work with them and coach them and counsel them over time. So there is some accountability that you can put into place that would help with these things. Let's see. I don't see one other comment. Yeah, just a comment of greed. Yeah, and those are the two human emotions that work against people when it comes to finance, is fear and greed. It's this pendulum that goes back and forth, and that's why the vast majority of people in this country retire with not a lot of money. They end up spending a lot of it early on, and certainly there's hardships, there's situations that happen, but in a lot of cases, the reason why somebody ends up making a bad investment decision or a bad financial decision, it's not because of lack of information. It's typically because they let their fears get the better of them, either greed, and this would be like buying Bitcoin when it's at 20,000, right? Or getting scared when Bitcoin's down to 3,000 because I just lost 70% of my money. So these are the things that a lot of people end up doing, and they don't mean to make bad decisions. I don't think anybody tries to make bad financial decisions, but oftentimes either they don't know any better or they don't have somebody to say, don't do that. It's not a good idea. We need to think through that and add some logic to the situation instead of just getting tied in emotionally. So anything else? I'll call last call here for questions. Let's see. Yeah, I think that's it for right now. But again, I'm open for consultation. Certainly, it's easy to do that. Just shoot me an email and we'll get something set up. I certainly appreciate your time today. Thank you for your support. Thank you for all the questions and the interaction today. Wish you the very best, and God bless as you go into your weekend. Take care.